This presentation is regarding the Probation Service, an overview of our work, the authority we hold, and an explanation of PPRC. The history of probation is that we were formed by the Probation of Offenders Act in 1907 with a remit to advise, assist and befriend. Radical changes took place in the 1990s where these values were replaced with public protection, enforcement and rehabilitation. There were further reorganisations that have taken place since the start of this century. In 2016, the service was split into the National Probation Service and many privately owned community rehabilitation companies. Both the NPS and CRCs ceased to exist in 2021 with the creation of a new single agency, the Probation Service. So the Probation Service responsibilities are to assess and manage the risk posed by offenders, to protect victims of crime and the general public. This is done by providing information and advice to criminal courts, other criminal justice agencies including the Parole Board and partner organisations. We supervise offenders subject to community orders and licences and during their custodial sentences. We contribute to the management of risk and we work with other agencies and groups to prevent crime and meet the needs of victims and offenders. Communicating with and prioritising the well-being of victims of serious sexual and violent offences when the offender has received a prison sentence of 12 months or more. Who do we supervise? So we supervise those people on community orders. These can contain various requirements such as curfews, supervision, drug treatment and unpaid work, and these are all enforced through the courts. We also have suspended sentence orders. These are technically prison sentences but served in the community with requirements attached. These are again enforced through the court with a higher risk of real prison time for a breach. Post-custody licences. Almost all prisoners will serve a period on licence with many strict restrictions. Most cases serve half their sentence on licence and breaches are managed through the public protection casework section, otherwise known as recalling them. Licences can be revoked in as little as an hour. There is also something called post-sentence supervision. The Offender Rehabilitation Act adds a period of PSS to any short licence such that the PSS and licence period combined will last for a year. PSS has few restrictions. The focus is on support and rehabilitation and is enforced by the courts. There are discussions at the moment about whether to withdraw PSS. We also have limited involvement with non-statutory cases via New Era. Community unsuspended sentence orders. These have requirements attached to the orders in court and these can include rehabilitation activity requirements or RAR days. This can include various interventions to address substance misuse, domestic abuse, education and training and anger and emotional issues. We can also have a programme requirement. This requires attendance at an accredited programme, usually in a group where greater or more focused intervention is required. These can include drink driving groups, anger management and domestic abuse programmes. Somebody can also be electronically monitored, have unpaid work, have a residency requirement, attendance at mental health treatment, alcohol monitoring requirements. Any breaches of the order or requirements are dealt with through the courts where fines or additional requirements can be imposed, or the order can be revoked and possibly custody issued in its place. In terms of licences, all licences contain standard licence conditions. We can also request additional conditions which can restrict contact or residence with children, participation in a programme, restrictions around item possession such as mobile phones, internet access, disclosing of cars, surrendering of passports, disclosure of information such as details of any personal relationships, as well as curfews, exclusion zones and electronic alcohol monitoring. We can also request bespoke conditions where a peculiar risk can't be addressed through standard or additional conditions. Recent examples include not using public transport, not carrying matches or licences, not owning a pet and always wearing trousers with a belt. Post-sentence supervision is where any licence shorter than 12 months has a period of PSS added such that the total period of licence and PSS will equal to 12 months. Whilst it has the same standard conditions as a licence, they cannot have any extra conditions attached to it other than alcohol or drug treatment or testing. As mentioned, PSS has a different focus to licences and should be aimed at support and rehabilitation. Contact levels with people on probation can change as well depending on need. Terms of enforcement, community orders and PSS are enforced through the courts. This process can take several weeks and any breach needs to be provided to the criminal evidence standard, i.e. beyond reasonable doubt. We can expedite breaches where there is an imminent risk. Breaches of licence are enforced through the PPCS or Public Protection Casework Service. The evidence test for a licence breach is to a lower legal standard on the balance of probabilities, i.e. 51% sure, more sure than not. Hearsay and third-party evidence can also be used to justify a recall. Recalls commenced in office hours lead to a warrant being enforced by 5 p.m. Emergency recalls will be fully processed in 2 hours. There is also an out-of-hours service available during all evenings and weekends. Where there is an imminent risk, recalls can be processed verbally over a very swift timescale, usually in well under an hour. Here's an example of some sample license conditions. Moving on to MAPA and what it is. MAPA stands for Multi-Agency Public Protection Arrangements. MAPA is in place to ensure the successful management of violence and sexual offenders. There are responsibilities of the police, probation and prison service. Other important agencies are also involved, ranging from housing, education, health, social care and the UK Border Agency. They require the local criminal justice agencies and other bodies dealing with offenders to work together in partnership. There are 3 sources of MAPA cases. Category 1 were all registered sex offenders. Category 2 are for violent offenders sentenced to 12 months or more. And Category 3, those who have been cautioned or convicted for an offence which indicates that they are capable of causing serious harm to the public and who, because of the assessed risk, need multi-agency management at level 2 or 3. There are then 3 levels of MAPA management. Level 1, single agency management. Level 2 are a multi-agency management with formal meetings taking place every 10 weeks. And Level 3 is multi-agency management with senior management oversight, meeting more frequently at every 6 weeks. For all cases, we have to assess their level of risk of serious harm. Starting at the bottom, low risk of serious harm, where there is current evidence does not indicate a likelihood of serious harm. Medium risk, there are identifiable indicators of risk of serious harm. The offender has the potential to cause serious harm but is unlikely to do so unless there is a change in circumstances. For example, failure to take medication, a loss of accommodation, a relationship breakdown or drug or alcohol misuse. High risk of serious harm are where there are identifiable indicators of risk of serious harm and the potential event could happen at any time and the impact would be serious. Very high risk of serious harm is where there is an imminent risk of serious harm. The potential event is more likely than not to happen imminently and the impact would be serious. When we make our risk assessments, we take into account information from a range of sources. This can include previous convictions, CPS documentation, the person on probation themselves, any partnership agency involvement, police information, and we then make a professional assessment that is defensible. Risk can be dynamic and will therefore change throughout a person's period on licence or on an order. Moving on to PPRC and what it is. This stands for Persons Posing Risk to Children. It relates to the identification, assessment and management of individuals who have committed offences against a child and have received a caution or conviction for that offence. It also applies to those who have committed an offence against a child, but where there has been no formal conviction, as convictions alone do not define ongoing risk. The PPRC process is for managing individuals who have a conviction against a child or whose behaviour directed towards a child gives cause for concern. Where concerns are raised about the welfare and/or safety of a child due to the criminal activity, behaviour or lifestyle of an individual, but where no offences against a child have been perpetrated, then the process for referral is the standard safeguarding procedures. So for those where there has been a conviction or caution for an offence against a child and there is no ongoing risk to children identified, there is no notification to children's social care requirement. Detail of the conviction and assessment will be recorded on systems with statutory management of the offender undertaken as required. For those situations where there is a conviction or caution for an offence against a child and an ongoing risk to children but no identified child in contact, a PPRC referral should be completed and marked as information only. This is then sent to the children's social care covering the address of the offender. For situations where there's a conviction or caution for an offence against a child and an ongoing risk to children confirmed, and a child is identified in contact with the offender, then a PPRC referral is completed and marked as assessment required. This is then sent to the children's social care covering the address of the child. The child's details must be identified in this referral. A separate PPRC referral for information is also to be sent to the children's social care covering the address of the offender if this is different. For those situations where no offence has been perpetrated against a child, but other criminal behaviour, attitude or lifestyle of an individual indicates potential concern for a child's welfare, and the person identified as a parent or carer or with significant childcare responsibilities, this would result in a referral under Section 47 of the Children's Act made to the Children's Social Care Duty Office covering the address of the identified child. The person identifying the cause of concern is responsible for ensuring a referral for assessment is made. Where there is a change in circumstance, the probation practitioner should generate and submit a new PPRC. This referral will outline the change in circumstances and identify the appropriate referral where a child is identified. Then it will be an assessment request referral, which outlines the circumstances of contact with a child. Where there is no identified child, for example the person has moved to a new area, then a referral for information only will be sent. At the end of a licence period or sentence end date, a reassessment of risk should occur. Where any persons whose risk to children has been addressed and where assessment concludes they no longer pose a risk to children, this information must be recorded and sent to the children's services holding the PPRC status. The responsibility for informing the individual presenting a risk to children sits with the agency assessing or identifying that risk. In exceptional cases only would a PPRC not be informed of their PPRC status. The reasons for not informing the individual should be clearly defined and recorded by that agency and signed off by a responsible manager. Here's an example of a PPRC form for completion. Here is a recording for the probation safeguarding processes in Staffordshire. Referrals are sent to the following email address. There is also a number that you can use. Thank you for your time. I hope you have enjoyed this presentation. Thank you.